Thank you all for coming, particularly on a day like today. I appreciate it. I'm Steven. I've been doing some work for the last couple of years on lawyers and climate change. So my research, half's on environmental law, half is on lawyers. Last couple of years bringing it together. And I've been in Canberra since Saturday, and I've been doing various things. I've been to the Botanic Gardens, saw some snakes. I've been to the Arboretum, and I've been to some of the galleries. And when I went to the Portrait Gallery, there was the National Photographic Exhibition that was on. And this is the first image that you see as you walk into the gallery. And it's a photograph from 2022 of two young men in Brisbane who, after the recent rains and flooding, were helping friends and family kind of rescue their possessions. Now, when I see an image like this that is recent, is about an adverse weather incident, I think of climate change. We know that these sorts of incidents are more likely to happen because of climate change. We know they will get worse. And what I tend to do these days is to kind of think backwards from those incidents. Where did they come from? Who was responsible for them? If we're thinking about allocating blame or thinking about the story of those events, who is relevant? And these days, I always see lawyers in images like this. So when I'm working backwards, I always see the lawyers. And why I was so keen to talk to you and your colleagues today as a student body is that I want you to start thinking in these sorts of terms. It's a little bit confronting, and that's okay, but it's also really important. So when, if you qualify and you become lawyers, you're looking back at your time in practice and the things that you did or didn't do for your clients, what will you be able to say about how you helped to worsen or lessen the climate crisis? Now, sometimes when I do these sorts of talks, it can sound like preaching. It can sound like I'm telling you to be better people. I'm telling you you're going to be bad people. I'm telling you I don't like you. But really, I'm doing this because I was the bad environmental lawyer. So I was the lawyer in practice for about 10 years. I did lots of work for BP. I did lots of work for the English government, for BAE Systems. I built power plants and roads and motorways, landfills, etc. And as I've gotten older and a bit more reflective about my life and the choices that I made, this is much more in my head. What did I do as a lawyer? And we're going to keep on coming back to this question. I'm also keen for you at any point just to stop me and say, can you say a bit more? Or better, I disagree, what about this? So do feel free to kind of chip in. How many of you are thinking of qualifying and going into practice? You don't have to, obviously. I should preface with that. Some of you? Okay. Yeah, seeing how you feel. I think the reason why I want to kind of come talk to you as well is that we often don't talk about these things so much. So you'll have law firms come in and do kind of glitzy presentations, or chambers or the government, and they'll talk about the great work that they do and how wonderful it is they work for certain clients. And I want to be, there's a phrase I use, a professional agitator. I want to come in and say to you, actually, that's great, but have you also thought about this? One of the other things I'm kind of curious if you're thinking about is, imagine you're the sort of person who believes climate change is an existential threat, that you want to do your bit to help climate change or other social and justice issues. Do you decide to go and work for the very largest law firms or chambers or for the government on the inside? Or do you try and work on the outside? We'll come back to that as well in a little bit of time. So when we're thinking about climate harms, climate change, the climate crisis, we'll often think about, the carbon majors, those group of almost 100 companies who are most responsible for climate change, BP, Shell, the mining companies. Or, because this is useful, we as individuals get made to feel guilty. We feel guilty that we didn't recycle our plastic cup or we took a flight. We don't often look at many other actors, and lawyers are relevant to all of these stories and relevant to all of these impacts, but they're hidden. And the whole point of today really is making them a bit more visible. As a kind of thing, the role of lawyers in relation to climate change is becoming more and more topical. So Extinction Rebellion, you'll all have heard of. In London, they are now protesting physically outside the front door of one of the largest law firms, Slaughter & May. There is a global debate about lawyers as, quote, professional enablers, asking, if the lawyers weren't involved, would these harms still be existing? And, as some of you may also know, law student groups, led by Emily here at ANU in Australia, beginning in America, are compiling databases. Which are the law firms who are most responsible for climate harms? What sort of work do they do? What sort of renewables work do they do, et cetera, et cetera? So all of this sort of stuff is becoming more and more topical. Now, when lawyers are doing legal work, they can either be climate conscious or climate blind about it. And what we mean is, are they reflective of the climate implications of the work that they are doing, or aren't they? Now, if you're a finance lawyer and you're asked to refinance an oil and gas field, hopefully you will get that there are climate impacts from doing that sort of work. But if you're doing other sorts of work, you're an employment lawyer, you're a residential lawyer, maybe you're a tax lawyer, whoever else you might be, the carbon harms are sometimes less obvious. They're climate blind. One of the points I want to make is actually all legal work has a carbon impact, some of it much worse than others, but all of it has those impacts. And what I've been trying to do is kind of categorize the sort of work that lawyers do. And I like things that kind of phonetically work. So I came up with the 4 L's. So when we think about the work that lawyers do, they lobby, so they advocate on behalf of their clients, maybe in relation to government policy, maybe in relation to legislation, maybe in relation to other things. They lubricate. This doesn't work, but I wanted another L. They lubricate, so they make things happen. They buy and sell companies, they raise finance, they give tax advice. They legislate. And by this, I don't just mean they help with legislation, but what lawyers do in the drafting of contracts, in debates about finance, in lobbying work as well, is they give certain sort of meaning to certain legal terms, and therefore can change the dial on what the law is, and obviously they bring litigation. So in all of these types of legal work, the climate is relevant, sometimes more obviously than in other contexts. Now, I hope the first sentence here is relatively uncontroversial given what I've just said. Solicitors are responsible for environmental and climate harms. So if you are the lawyer and your client wants to build a new fossil fuel powered station, without your legal advice, they probably wouldn't be able to do it. So if we're telling the story of that fossil fuel power plant, which is making climate change worse, then lawyers are relevant and responsible. Now, it doesn't mean there aren't good reasons for that responsibility. We'll come on to that in a second. But as a starting point, lawyers need to accept that responsibility. When I go and talk to practicing lawyers, they find this very confronting. They find this a very hard sentence, to accept that they are responsible, even if there are reasons or kind of arguments which mediate or displace that responsibility. And responsibility and blame are different things, and I'll come back to that as well. I'm hoping you're a chatty audience. Are you a chatty bunch? Good, got some nods. I'll take that. So why do you think this is? Why is it that lawyers might be willing to do things for their clients that exacerbate or do not improve the climate crisis? So if you're a lawyer and you're working in a very large law firm and a client comes to you and says, we'd like to buy this oil field or we'd like to build this fossil fuel powered plant, why might you be willing to do that? Any thoughts, any comments, or indeed any questions?
I think because you're not the one doing the doing.
Yep.
You're just the conduit, the facilitator.
Yeah, so this is a really kind of interesting point. You're not doing the doing, you're simply kind of, you're a vehicle. Your client wants to get to destination A, and you're like a motor car. You're simply helping them get to that point. You're not the decision maker. We'll come back to that in a second.
I guess very basically, like you're getting paid to do so.
Yep.
And I guess the really common excuse is like, if I don't do it, they're going to go to someone else and they'll do it for them. So.
Yeah. So 2 points there, both important. One is you're getting paid to do it. So there'll be a contract here. So you're providing a contractual service. If you said yes, you sort of have to do it. Whether you say yes, we'll come back to that in a minute or two. And then the second point, which is if I don't do it, someone else will. And we'll come back to that later as well. But that happens a lot. When I go and talk to practicing lawyers, they say that a lot. Any other thoughts?
Say as lawyers, I'd like to see themselves like removed from the politics, removed from the rest of the world. This just kind of exists in their own kind of bubble as well.
Yeah, exactly that. Thank you. Yes, this idea of neutrality. Lawyers like to think of themselves as neutral amoral technicians. This point, it sort of links onto the vehicle point. We are the vehicle. Nobody blames the gun for killing somebody. That's it's a stark statement, but that's sort of where we are. We are simply neutral in all of this. There's another thing as well, which lawyers say quite a bit, which is, well, it's legal. So if my client comes to me and says, I want to buy this oil field, and it's legal to do so, who am I to say to the client, no, I'm not going to do that for you? Or who am I to say to the client, you shouldn't do this? So all of the things you've said come up in the conversations I have with practicing lawyers, plus this. If it's lawful, that's the end of the conversation. And I want to challenge that a bit. Is that really the end of the conversation, or can we carry the conversation on forward? And if I was being cynical, what I would also say is this is a very helpful argument for the lawyers, isn't it? Because this basically says, I don't need to do any more thinking. If a government, a parliament has said something's legal, all of that kind of debate and reflection has already taken place. I, as the lawyer, don't need to engage in that. And we'll come back to that in a bit as well. So in terms of regulation, if it's legal, you should do it. That legality is both about the legality of the thing that's taking place, buying the oil field, raising finance, but also about the law of lawyering that shapes the conduct of lawyers. And in different jurisdictions, lawyers are regulated differently. So I'm doing some work at the moment looking at the rule of law in different legal jurisdictions, and it's interesting to me how that does or doesn't come up in the legal rules. But in looking at all of those regulatory codes, the law of lawyering, none of them seem to say to a lawyer, the only thing you have to think about is your client and your client's best interests. None of them say that, or none of the 36 I've looked at in the last few weeks. They all say that. They all say think about your client and your client's interests, but they all talk about other things. And the reason for that is this special place of lawyers in society. Lawyers as professionals occupy this particular role where they are meant to use their expertise in the public good. And that's kind of big. The public good, there might be a public good in having fossil fuel power plants. Why would that be? Why would there be a public good in a lawyer helping a client build a fossil fuel powered plant?
Jobs and growth.
Yep, jobs and growth. No, I mean, yeah, really important. That is really important. The economy, finances shouldn't be taken out of consideration. Yep. Any other thoughts? Energy, yeah, exactly. And in some places, actually, fossil fuel plants are still sometimes the best way to get energy to those communities. Yeah, so both those things. But in the rules, very rarely do they say only think about your clients, don't think about anybody else. At home, in England and Wales, we have a very complex regulatory system. We have 9 types of regulated lawyer, so solicitors and barristers, I'm guessing you've heard of, but we also regulate as lawyers accountants who do legal work, notaries, cost lawyers, conveyancers, etc., etc. It's a kind of complex and yet fun regulatory system. Obviously only an academic would call it fun. And at home, we have these set of principles that tell lawyers how to act. So in the Code of Conduct, these principles sit at the very front of the regulatory rule book, the law of lawyering, and they tell lawyers what to do. You act in a way that upholds the constitutional principle, the rule of law. You uphold public trust and confidence with independence, with honesty, integrity, in a way that encourages equality and in the best interest of each client. And what all of these things are saying is that point I made earlier. Lawyers have a special place in society. Yes, they act for their clients. Yes, they're providing a service, but it's much more than that. It's all of these other things at the same time. And 2 points I want to make from that. One on independence. So independence is a professional idea that is seen in most rule books on lawyers, this idea of you being an independent professional. Now, when you talk to practicing lawyers, they think of it only in one sense, which is, I am independent from the state. I'm going to help my client. I'm going to help my client enforce their legal rights. The state cannot interfere with my ability to help my client. What they forget is that all of the accounts on professional independence says that independence works in 2 ways. It's independence from the state, don't mess with my client, but it's also independence from the client. I'm an agent of the rule of law. I'm going to help you do things that are legal. I have this special social role. And what I think that independence does, plus other professional principles, is it says to lawyers, you are not just the car. Or if you are, you're sort of an AI car. That's probably not very good. Let's roll with that. You're an AI car, so you get to make some kind of reflective decisions. You're not just thoughtless. There is an element of thinking and reflection going on. The other thing which I think is interesting these days is this. What does it mean to act in the best interests of your client? What does that look like today? And the reason that I say that is we have lots of environmental, social and governance, ESG, laws, principles, guidelines. They operate locally, nationally, internationally. Companies, governments are being increasingly pressurized to take these things seriously. What does it mean in terms of modern slavery? What does it mean in terms of the climate? So if you know that, and you should, you're a practicing lawyer, when is it in your client's best interest to allow them to harm the environment, even when it's legal? And of course, that's a big question. It's not a kind of simple question for today. That's a really big question. So we come back to this idea of climate-conscious lawyering. Dr. Kim Bua of Durham University wrote about this first, and Chief Justice Preston of the Land and Environment Court in New South Wales has been following it on. And what they're both saying is that when you are acting as a lawyer, you need to be thinking about the climate. That you cannot ignore the climate impacts to your legal practice, both to what you're doing and to what your client wants to do. And this sort of idea is taking purchase in lots of jurisdictions, and it's seen in some regulators as well. I'll come back to that in a second. You may have already looked at this. Yes? Okay, just a second with Jess. So have you all studied lawyers' ethics? Yeah. So my knowledge of the Australian rules and state rules, not great. But actually this doesn't look a million miles from what we have in England and Wales. What's interesting to me is your paramount duty, this duty to the court and the administration of justice. We have something similar at home, which says this. Should the principles come into conflict, so independence, integrity, rule of law, acting in a client's best interest, those which safeguard the wider public interest, such as the rule of law, and public confidence in a trustworthy solicitor profession and a safe and effective market for regulated legal services, those principles take precedence over an individual client's interests. So both at home and what we see here is a sort of, should be a statement of kind of reflection for practicing lawyers that their client is not the be-all and end-all. Doing what your client wants is not the be-all and end-all. And this idea of using the principles in the public interest, that comes from many decades worth of writing and theorizing on professionalism. What does it mean to be a professional? Well, it means using your expertise in the public interest. Also many decades worth of people saying, well, lawyers and other professions don't do this. They just want to charge money for themselves. They want a monopoly on services. They're not actually that bothered about the public. I am perhaps slightly naive because I still believe in this. I still believe in the public interest element of professionalism. So let's think about the public interest. We've done a little bit of this thinking already. But when might it be in the public interest to irreparably harm the environment? So we've had some thoughts about kind of local energy and energy production, which is definitely right. What else do you think? When would it be okay? And we've had some comments on jobs and kind of local economies and generally the economy. When else might it be in the public interest to harm the environment? What do you think?
Infrastructure?
Yeah. If you're kind of building infrastructure, yeah. So kind of societies are not just about the environment. Societies are about social rights. They are about the economy. They're about politics, culture, etc., etc. And when we're thinking about this, how do we put those different social goods, those different social needs together? So, for example, there was a lot of litigation in the UK about air quality. We have very polluted air quality, particularly in London, sadly. And one of the most polluted roads in Europe is outside the building where the law faculty sits. So I always tell students, take a deep breath on day one, and we talk about air quality. But one of the arguments the government ran in this litigation was it would just cost too much to make the air quality better. And did people want the government spending that money because they'd have to take it away from the National Health Service? So in an economy with limited funds, what did people want us to do? Did they want better air quality or did they want health? Now, that is a very binary argument. It's a very blunt argument, but that is sort of what's sometimes going on here. The public interest is more than the environment. Interestingly, when you give the public opinion polls on different things, at home at least, the environment comes in the top 5, but the public is more interested in health and defence and the economy, sometimes migration, very sadly, because that's not a positive at home, it's a negative, and then the environment comes below. So when you're asking what is in the public interest, it's kind of a complex question. It's why this is an interesting field of study. So I'm also interested in what regulators are doing. So if we accept lawyers are responsible for climate change, well then legal services regulators who regulate the lawyers, what role should they play? Should they be saying anything at all? What do you think about that? So imagine you're a legal services regulator. You regulate solicitors or barristers in a particular jurisdiction or federal level or in another country. Do you think it's your job to be saying anything about climate change or not? Arguments either way?
I think it's useful to have like guiding principles, but I guess how useful are guiding principles in the kind of where we are at the moment. But I don't think it's kind of their role to decide what lawyers can and can't. Yeah, it's a tricky question.
Yeah, well, I think that kind of 2 points there, thank you. One is kind of guiding principles. So how soft or hard are you going to be with the direction you give? So if you're going to say something about climate change, you have choices. You can either be, here is a rule on climate change, and if you breach it, we will enforce against you, and there might be consequences. Or you can say, here's some guidance on climate change, we'd like you to think about it, and if you haven't taken it into consideration, that probably doesn't have regulatory consequences. That's really important. But what's the job of the legal services regulator? Is it their job to say something about particular quote-unquote social issues? Did you have your hand up as well?
Oh, I was just going to say, could it potentially be viewed as overstepping the role of government?
Yeah.
And other, more official regulators?
Yeah, very much so, and that's often what gets said. That actually, this is not for us. If the government wanted us to do something, they'd amend the legislation, or they'd just tell us. We have regular meetings with the government. If they wanted this to happen, they would say it. And that's kind of one of the kind of sadnesses about climate change, I think. So when you look at the Paris Agreement, which is 2015 international agreement on climate change, global commitments to reduce global temperatures. 170-something countries now have ratified it. Everything we need is in that agreement. Everything is there. All we need is the governments implementing the international promises they've made. So the idea that we just need to wait for governments to tell us what to do is what gets said, but actually I'm a bit skeptical about how likely that is. At home, we have the Law Society, which is a representative body. It's written some guidance on the impact of climate change on solicitors, and you may have seen this document from the Law Council of Australia. Broadly, they say similar things. Broadly, they say climate change is a thing. You need to be thinking about it. It will impact on your legal practice, and you can't ignore it. Broadly, that's what the two documents say. But at home, there we are. But at home, the regulator, the SRA, hasn't said anything. And what they say publicly is, we don't speak on particular issues. This is not an issue that we speak. We don't talk about human rights abuses, or we don't talk about whatever else it might be. So we're not going to talk about climate change. And yet, that's a kind of a lie, because at home, the regulator has done topic area guidance. So they've done one on employment law and non-disclosure agreements. So where you as a lawyer help your client silence the victim of sexual abuse through an NDA, the regulators said something about that. And they've said something about Russian oligarchs who are trying to use the English courts and the threats of defamation to silence journalists. They've said something about that. So I say to the regulator, well, you think those two things are important and important enough to say something publicly. What's different about climate change? And climate change as an issue is more complex, politically, economically, socially, and they're not quite there yet. They're not quite ready to say something. So we've been talking about the laws of lawyering, but that's only really the beginning of the conversation when we're thinking about what we expect of lawyers. So because they are professionals, we do and should expect more of them. We expect them using their expertise beyond the law of lawyering. That's where legal ethics comes into play. So when you're being asked, what does legal ethics mean? Well, often there are a body of theoretical, sometimes other approaches that are saying to us, how should lawyers act? It's both a general question, how should lawyers act generally, and it's even where you have a law of lawyering, the law tells you what to do as a lawyer. What if that law is deficient? Or what if that law is kind of missing, there's a bit kind of out of it? Or what if we don't know what the law means? So for example, we don't really know what it means to be independent, and yet there is a rule saying you have to be independent. Perhaps theories of lawyers' ethics can help us understand what that looks like, how that actually lands. So we're going to do a little bit on the theories. Practicing lawyers tend to forget the importance of professional ethics and theory, and yet we get told by courts how important this is. So this was a disciplinary case in the UK, and the tribunal, who was kind of writing the judgment, says this: a solicitor must and should on occasion be prepared to say to his client, what you seek to do may be legal, but I'm not prepared to help you do it. A very powerful statement. Sadly, the only one I can find, but a very powerful statement nonetheless. And this tribunal is not known for making powerful statements. It's very kind of boring and anodyne. But this is really important. What this is telling solicitors, as a matter of law, given it's coming from this tribunal, is the fact that something is legal is not the end of the conversation. You need to do a bit more thinking, is broadly what it's saying. And I won't read the whole quotation out, but there is this great report, this Royal Commission from Melbourne into the casino operator and licence, and Ray Finkelstein, AOQC, KC now, says the same thing about the obligation on practicing lawyers to give moral advice, the requirement to ask, is it right? Is it honest? Does it thwart the purpose of the law? And just assume the slides can go to the students if they'd like to see them. Okay, so I'll move on past this. But the point is, both at home and here, that message, is it legal is not the end of the conversation, loud and clear. Now, since the 1950s, 1960s, there have been different competing theories of lawyers' ethics. And they are all trying to provide justification for how lawyers act. And four broad theories, which I think you'll come on to study soon.
We're talking Parker.
Standard conception. Yeah, Parker's for however Christine calls it. Okay. So you already know this. Okay. Actually, that's good. What do you know about these four competing theories of lawyers' ethics? How does Christine talk about them? Christine Parker in her paper. Do you remember any of the names? My students hate it when I do this. Normally, I'm saying, last week we talked about this. Do you remember? And they go, no. Life has moved on in a week. So standard conception, first one, this idea of a lawyer who is amoral, is not to be tarnished with what their client does, is not accountable for what their client does, is partisan, does what they can to help their client. A justice-seeking lawyer who is more interested in the... Yes, I'm not going to comment on the facial expressions. A justice-seeking lawyer, an ordinary morality lawyer, and then an ethic of care. I'm not going to go over these because you already know them really well. But the point is that these are competing in the sense of they are all trying to provide a single best explanation for how lawyers act. But none of them is winning. The standard conception, the amoral lawyer does what they can for their clients, not to be tarnished with their clients' actions, is the most dominant. And all we mean by that is it's the one that most legal philosophers think is the most valid explanation of how lawyers should act. But simply because it's dominant doesn't mean it's right. And you need to remember that. Simply because lots of people agree with it doesn't necessarily mean that it's right. And one of the things I'm trying to do with some of my work is to come back and challenge some of these theories. So with the standard conception, don't judge me for what my clients do. I'm just a neutral advisor. I help my client out. If you were a lawyer who believed in that conception, this is what your argument would look like. You'd say, well, regardless of how I feel about my client's plan to harm the environment, we live in a world with complex and competing views on natural resources, health, poverty, the economy, and so on. And laws have been democratically made which set out what my client can and cannot do. It's not my job to judge my client for seeking to do things that are legal. Clients get to decide what they want to do, and they need me as a lawyer to help them do what they want to do, even if the environmental harms are really significant. And actually, in our conversation together today and your kind of comments back, we've covered most of this. This is the kind of beginning of the standard conception. And my experience has been of law students that they come to law school often with a sort of justice mindset. And then by the end of their first year, that's been reoriented towards a more corporate mindset. And then by their third year or their final year, they're sort of 50-50, depending on which modules they are taking. So in my environmental law class, I see lots of the kind of justice-oriented students. And when I teach company law, I see lots of other students. But this is the standard conception. This is kind of how it would look. And in the work I've been doing, I've been trying to ask a whole series of questions. So this idea is if it's legal, it's okay. Well, in environmental law and in lots of climate law, we talk about it being hot law. Liz Fisher at Oxford kind of coined that phrase. And what she means is it's very uncertain. Environmental law is inherently uncertain. It's a polycentric mix of facts and kind of opinion. It's science, it's politics, it's economics, etc. We're always contesting things in environmental law. So when someone says, as a lawyer, it's legal, that might be more complex in environmental law. Equally, lots of the standard conception is about individual rights. The standard conception comes from criminal defense. So you are accused of a crime, your lawyer's got to help you fight the government, fight the state, because the risk of lack of liberty, you going to prison, is really significant. Your individual interests, your individual liberty, your individual autonomy is really important. That's often not the same in environmental law. If we're thinking about climate change and we're thinking about the actions we take as individuals or governments or corporates, we need to be thinking about the collective. And that's often one of the reasons why climate change is hard. It requires people to think not just about themselves, but about other people. And this also challenges the standard conception. What I'm going to do, just quickly, because we've got 10 minutes before I need to run off for my rescheduled flight, I'm afraid, is skip through, and I might just leave it in there, but give you 10 minutes for questions or discussion or comments or anything else you want to raise in this space. Is that okay, Jess? Have I finished this?
Yeah.
Leave. I'll stop prattling is what I'm saying, and I'll start hearing from you. Do you have any questions or any thoughts? Why did you come here today out of the many students? Anything you want to share or ask?
I guess the most significant thing I think about is, again, the fact that, you personally might say to your client, I'm not willing to help you with this.
Mm-hmm.
They're going to most likely turn around and go to another firm.
Yeah.
Who most likely will do it for them.
Yeah.
So are you actually really having any impact by, staying with your values?
Yeah, it's a really good and hard question because you'll never know the counterfactual. You'll never know what the world would have looked like. But more than that, it's also kind of valid in the sense that happens all the time. So think about work for tobacco companies. So in London, lots of law firms just made the decision they just wouldn't do tobacco. It doesn't mean that the large tobacco companies haven't got representation and haven't got representation from really large, really competent law firms. It just means that a group of law firms decided that they wouldn't do it and some others would. There is something, though, I think, about how you sort of look at yourself in the mirror at the end of the day. And that's really tough because you might be saying to yourself, I'm staying in this firm and working for this client or for the government or in-house. Because even though it's really hard and even though I disagree with 87% of the things they're doing, I'm trying to kind of leverage the 13% to be bigger or better. And that's partly about your own sense of kind of how you see yourself and how, don't really love the word resilient, but how resilient you can be to kind of accept those kind of challenges. And some people leave and some people stay. The other thing that's happening a lot at home is sort of a form of conscientious objection. So young lawyers will go into law firms and say, I'm really happy to work for all bar 2 of your clients. I just won't do it. And actually that's sort of what I did, although I'm not a young lawyer. So when I went to my first law firm, I did BP and BAE Systems, but I wouldn't do tobacco work. My mum had died from smoking when I was really little, and I just couldn't do it. And the firm was fine, and then they weren't fine. Then they were like, why don't you just do a little bit? It's not actually, it's only for the HR team, it's not really for the main tobacco team. And so I left. I couldn't kind of reconcile my own feelings. But yeah, it's really tough. It's a really good question, but it's a really tough question.
I think that's a really interesting question because it brings us back to your responsibility as an individual on the ground on the day. what should be the role of the regulator in those circumstances by taking pressure off young lawyers and
Yeah.
young people going into the profession. And I was thinking about the young barristers and the barristers' strike last year. It's all very well for the KCs who were leading it to stick their heads out.
Yeah.
But with the response from the Bar Standards Board and everything, that put young barristers in a really tricky position.
Yeah, and being junior is really tough. So it's tough in two ways, I think. One is that, very sadly, from a whole suite of behavioural ethics work, we know that whoever you are on day one in a large organisation, you're not that person a year later. So Kimberly Kirkland, who's done great work on lawyers, talks about looking up and looking around. So you look up at the other lawyers more senior to you in your peer group, at what they do, what they think is okay. And then over time, you start to think those things are okay as well. And the other is about sort of your employment relationship. So when the barrister strike was happening and when there was this work and conscientious objection, I was kind of I was advising a group about not the employment law aspects, but how to get employment law advice. So you are the junior lawyer who says, I'm very happy to do all of this work, but I won't do that work. What can the law firm do to you? And the reason why that's necessary is I worked in these large law firms at a point in time when various of my peers went off on maternity leave, and they were exceptional lawyers and they had exceptional appraisals. Then they came back from maternity leave and suddenly their appraisals were awful and they were asked to leave the firm in the next 6 to 12 months. So what we know is that large law firms can do whatever they want sometimes to junior lawyers, and sometimes pay a bit of money but otherwise get away with it. Did you have your hand up as well?
Yeah, I was just wondering, do you think maybe going into the future there's more of a role for lawyers as like ethical advisors as well as pure legal advisors? So like in that area of what you said, environmental law is incredibly changeable law. You can say, well, technically this is legal right now, but based on these principles, if that keeps evolving in this way, then it might not necessarily be. Yeah, I don't know.
No, it's a really good question. And I think the short answer is yes. So if you'd spoken to lawyers in large law firms 20, 30 years ago, they would say they were trusted advisors. That's a phrase that's always used. We are a trusted advisor or consigliere, depending on how posh the lawyer was. We have this special relationship with our clients where they come to us, they want to hear our opinions, they value us. The last 20, 30 years, at home, here, everywhere, for various reasons, value for money has come in terms of your relationship with your lawyer. And what it's meant is, as kind of lots of my empirical work, there's a great quote, we are seen like the photocopying people. We are just another service provider. So lawyers historically, kind of last 20, 30 years, not had that relationship. What's changing now, however, is with the rise in the importance of ESG, clients are saying, yeah, if it's legal, that isn't just the end of the conversation. We are needing broader advice. So every large law firm in London, I'm only laughing because it's just so ridiculous, every large law firm in London now has an ESG practice. And when I go and they say, oh, it's great, I love it. Who's in it? And they go, every member of the firm can be a member of the practice. And I was like, so nobody is a member of the ESG practice. But everybody has that practice because the clients want to have those conversations. And part of that's about reputation, part of it's about profit, part of it's about kind of changing social attitudes, et cetera, et cetera. So, if I was, that might be kind of shifting the dial a little bit. What's also happening in some of the largest firms is the more environmentally conscious clients are coming to the law firms and saying, we don't love that you act for BP. We don't love that you act for Shell. We actually care about the environment. And we are worth $10 million to you every year. So you need to do some hard thinking about what you're going to do. And that's also interesting to me. Sadly, no law firm has taken any action yet, but it might happen. Any other comments?
So, how do you separate the kind of the very obvious Shell, BP, whatever, from things like defense companies who do a lot of good science work compared to do a lot of arms manufacturing, or there's some other kind of more grey area examples. How do you kind of separate? How do you kind of find that kind of moral code, that line that you draw in the sand about who to represent?
Yeah, I'm smiling because I get this a lot in the law firms, and I don't have a great answer still. It's a question that I need a good answer for. So what I say to the firms is, I think what they should do is kind of sit down with a list of their clients and try and put them in groups, and there'll be rubbish groups, and they won't work. But there'll be some that they will think are the most problematic, and then some that are middle and some that are totally fine. But to do that, they need to have decided as a firm what problematic looks like. What does problematic mean for that law firm? The challenge there is that because people are people, everyone has individual preferences and views. So some people are happy to work for gambling companies or for pornography companies or for arms manufacturers, and others aren't. And when you have partnerships, which are meant to be about collective decision making, getting the partners to agree on what is good and what is bad and what is in the middle is really tough. So the thing I say is, actually, that is all of that's right, and I'm going to put that mess over here. The easier mess is, why don't you just have the conversation about the carbon majors, those 96 companies and state entities? Start there. Start with those 96. Then the conversation becomes, well, we want to act for BP because we also do all the renewable energy work. Don't you want us to be building renewable energy facilities and infrastructure? And then that's, again, a harder conversation. But the thing that kind of gives me some hope is that those conversations are happening when they didn't happen 5 or 10 years ago. And all I want, because I'm a bit of a realist, is the conversation to happen, because it just isn't happening in every law firm, but it's happening in some of them. You'll notice that wasn't a very good answer to your question. I hope you don't mind that. Any final questions? Doesn't have to be.
We're pretty much on.
Yeah. Thank you.
Thank you so much, Stephen.